He was at 3571 and she's or $3,500.71. She's still at that?
She is, Your Honor, and this is one where an answer, I believe you told her to file an answer. She filed it. The court sent it to me. It doesn't say anything. There's no attachment. I'm not sure what the defenses are. And frankly, Your Honor, I don't know if you recall, but this particular resident was in another unit. We generously waived her entire balance because she had repair issues. We moved her into a new unit. Now she hasn't paid any rent.
I was locked out in the middle of moving.
Sorry.
I was locked out in the middle of moving and they didn't help me with like what we agreed upon.
You were locked out and they didn't help you. What do you mean by that?
So remember how we were talking about how I couldn't afford a moving truck and that they will figure out something for me.
Right.
They locked me out in the middle of moving. And when we got access, which was end of May, a lot of my stuff was stolen, including a firearm, all my small kitchen appliances, my daughter's brand new sheets, my security cameras.
So what do you mean they locked you out? I don't get it.
Like we didn't have access. Like they changed the locks.
On my previous.
Yes. I did not render the old keys. And also.
So in essence, I just want to shortcut this. In essence, you're saying they changed the locks before you got all your stuff out.
I don't know what to do at this point.
Your Honor, if I can add, I would respond, but I'd rather have Amy respond because she has direct knowledge of what happened, because I don't believe that's our position. And I also don't believe it's relevant to this case, but that's a separate issue. I think it's worth responding to.
This case starts with a balance of roughly $3,500, but very quickly it becomes much bigger than unpaid rent. The tenant saying she was moved from one unit to another, locked out during the process, and lost property, including a firearm and personal belongings. The landlord's side says that is not the real issue today, because this case is about the new unit and the unpaid rent attached to it, and that is where Judge Simpson has to slow everything down. In housing court, emotions can be real, losses can be serious, but the legal question still has to be organized. What unit is before the court? What rent is unpaid? And what defenses actually apply? This is already messy because both sides are trying to control the frame of the case. One side wants rent, the other wants the court to understand the history behind the rent. And once Judge Simpson starts asking questions, the entire story begins shifting.
Your Honor, that's absolutely not factual. She signed a whole new lease, and I don't think I don't think Ms. Lutkoff or anyone would volunteer us to pay for a moving truck or use my maintenance guys to move her belongings, which is what Ms. Bannock seems to be under the impression that we offered her in court. She was given plenty of opportunity. In fact, there was a lot of grace given here to remove her stuff. And in fact, she came in our office on several occasions saying she didn't have a babysitter. She had to work. Her boyfriend had to work, all these reasons. I locked down the apartment upon her signing a new lease, sir. She took possession of a new apartment, Your Honor. And yes, I locked down the unit. She did turn in keys to our box. And so I took possession of an apartment that she no longer had possession of, Your Honor. And she left belongings.
Was there stuff in there?
Yes, my stuff was in there.
There was
and
boxes,
right now.
I believe.
I have the keys.
So what?
The keys are in my bag.
I can't say whether she kept a set of keys or not, Your Honor. But what I do know is that way later after the fact, after she's been in this other apartment for quite some time, she's bringing up issues of stuff that she wanted out of the old apartment. And at that time, I had already started a trash out, Your Honor. I mean, she signed a whole nother lease.
Your Honor, I think there was an issue.
I understand she signed a whole nother lease, but I'm just trying to figure out what period in time are we talking about?
I have a timeline. So
Your Honor, I'm going to just state for the record here that factually, just from a legal perspective, if she wants to pursue, she certainly can file an action for damages if she feels that her property has been damaged on another unit, but we're in court on this unit. And so I don't believe it's
Well,
relevant.
yeah.
And there it is, the first major legal clash. The landlord's attorney is trying to separate the old apartment from the new apartment, basically saying, if property was damaged or lost in the old unit, file a separate damages claim. That sounds clean on paper, but Judge Simpson immediately sees the problem. The new unit only exists because of the old unit dispute. So pretending these two situations are completely disconnected, that does not land well. This is a classic courtroom moment where legal technicality meets practical reality. The attorney may have a valid argument that damages belong in a separate action, but the judge is saying the background matters because it explains why the tenant is raising objections now. Question for viewers: do you think the old apartment issue should count as a defense to unpaid rent in the new apartment, or should it be handled separately? That question is exactly why this case gets complicated fast.
Yeah, but this unit, Miss Luckoff, that's disingenuous because this unit only comes about because of the issues that were in the other unit. So to try to separate them out doesn't make much sense.
Well, I think it does, Your Honor, because she didn't remove her belongings, but obviously this is your courtroom.
Okay, but
I'm just
that may be a defense to what she's claiming if she didn't remove the items. That may be a defense, but to say it has to be a whole another separate thing, I don't think that that's true.
Well, I do, because we're talking about a certain property
Okay,
address.
then
None of
I'll
that.
take what she filed. I'll tell her to go up there, stamp it in as another case, and it's just coming back with this one. I don't know where that gets us.
Well, I don't know what she filed. I mean, she didn't say anything in her filing, so, but that's fine. You want to consolidate it, I don't have an issue with that. We can provide you documentation
Well,
as
you
to
can
what
have an
happened.
issue with anything. All I'm trying to do is get to the bottom of this. Bottom line. That's all I want to know. And I want to know where I'm going to take this case. So she can have her objections, you can have your objections. We're going to do it my way. Go ahead, man.
All right. So the reason why we're here is because I feel like I can't trust their maintenance people because my stuff was stolen. I don't want anyone coming into my apartment.
Ma'am, you were at the point of a timeline.
Yeah. So the timeline is I think we did our court date like April 26th, I think. And that's when we dismissed the case, which honestly, I wish we had set things and whatever. And then that next week or that Friday or whatever they had to finish with the apartment, I think we grabbed the keys like that Friday. So then we started that weekend because I was working 2 to 10:30. So we were putting the kids to bed and then we were getting the stuff. Plus, like I said.
Okay, fine.
Couldn't move it.
So how much time passed between the time that you got the keys to the new place?
It was like a week and 3 days. And
so
then we
10 days
Yeah.
passed.
This is the turning point. Earlier, the tenant's position sounded like she was suddenly locked out before she had a fair chance to move. But now, under Judge Simpson's questioning, the timeline becomes clearer. She had about 10 days of access after getting the new unit. That matters legally. A judge is going to care deeply about timeline because timeline separates a strong defense from a weak explanation. If someone is locked out immediately, that may create one kind of issue. But if someone had a week or more to remove belongings, then the court starts asking, was that enough time? And Judge Simpson is clearly moving toward that question. This is why courtroom testimony can change the entire temperature of a case. One detail, 10 days suddenly weakens the emotional force of the tenant's original claim. Not because losing property is unimportant, but because the court has to decide whether the landlord acted unlawfully or whether the move simply was not completed in time.
And we lost access for 3 weeks. We didn't get this.
Oh, ma'am, stop. You had after you moved into the other apartment, you had access for 10 days.
Basically, yeah.
And you couldn't get all of your stuff out in 10 days.
No.
Okay, that's going to be a problem for you. They can't hold the apartment open for you to go in and move out in that fashion. You don't get 30 days to move out.
I understand. It would have been quicker if we could have just had that one last day.
Ma'am, I'll be honest with you. If you're telling me you made it sound initially like they locked you out, and that's all I was trying to get to the bottom of.
Yeah.
They didn't do that. It seems like, and by what you're telling me, you get the other unit, you've got 10 days. And you don't get all your property out in 10 days.
Well, technically, we didn't even have 10 days. They only gave us a week, but.
Okay, and that's even my point.
Yeah.
My point is 10 days would be extraordinary grace to get your stuff out.
Yeah.
A week, maybe about normal. That you move from one unit to the next unit. Maybe
What
get
about the previous agreement that some help was going to happen?
Ma'am, I don't recall that being
Can
the
we look
issue.
over the transcripts, please?
The transcripts of what? If you want to order transcripts, you can.
I tried. I haven't gotten a response.
Your Honor, I have not received a request for any.
It was a month and a half ago, granted. Sorry.
No, ma'am. You made a request for transcripts to my staff?
Yes, I did. I called and then they told me to email her.
Email who?
Whoever, I don't remember the name.
Now the case takes another sharp turn. The tenant says she tried to get transcripts, and Judge Simpson immediately focuses on whether court staff actually failed to respond. That may seem like a side issue, but in a courtroom, credibility is everything. If a person says, your staff didn't respond, the judge is going to test that claim because it reflects directly on the court's process. And Judge Simpson is not casually letting that slide. He asks for the email because he wants proof, not vibes. This is also where the tenant's position starts getting risky. She is already fighting unpaid rent, alleged stolen property, maintenance concerns, and now a claim involving court staff. When too many accusations pile up without documents, judges tend to become much more cautious. Viewers, be honest. If you were Judge Simpson, would you pause the rent case to investigate all of this? Or would you force both sides to trial and make them prove everything with evidence?
Well, you're going to have to show me that email because I'm going to be honest with you. If you're telling me my staff did not respond to you or did not address that.
Okay, give me 1 second.
Sure. Ma'am, while you're looking for that, who was supposed to help you move?
I'm not sure. Apparently, I mean, it said that they will figure something out because I literally said I could not afford a moving truck.
Ma'am. Okay. So you go over to this new unit and you have not paid any rent in that new unit.
No.
And your justification for not paying rent in the new unit is because things got stolen from your other unit.
Yeah. There's some major issues with my new unit though. And they said it was good to go. It's not good. It was not good to go.
Ma'am, you paid no rent. Nothing.
I don't think it's okay to steal someone's stuff.
Well, they didn't steal it.
Except they did because we made an
You know
agreement.
what? Here's what we're going to do. We're going to set this for a trial. We're going to set this for a trial on an expedited basis. Because did you find that email to my staff? Because I don't believe that you're telling me the truth. Because, ma'am, I'm going to tell you what. When somebody tells me my staff didn't respond.
I did call up here. I will say that.
But you said you sent an email.
Yes, unless it didn't. Oh, it didn't. Well, I have it on here, but I didn't send it apparently.
That sentence hurts her credibility badly. The tenant claimed she emailed about transcripts, but then admits the email apparently was never sent. And Judge Simpson's reaction makes sense. He is protective of his staff because the allegation was that they failed to respond. But if no email was actually sent, then the accusation collapses. This does not automatically decide the whole rent case, but it absolutely changes how the judge may view the reliability of the tenant's statements. Court is not just about what someone feels happened. It is about what can be proven. And here, the judge is basically saying, do not come into court accusing staff, landlords, maintenance, or anyone else unless you can back it up. At the same time, he does not dismiss the case outright. Instead, he moves toward trial, which is important. That means the tenant still gets her chance, but now she will need witnesses, records, photos, messages, and evidence, not just frustration.
Well, I'm not going to make you apologize to my staff for trying to say they didn't
No,
respond.
I-
No, ma'am, I'm just going to tell you right now. Here's how I work. And my staff knows this. If somebody wants something from them and they're supposed to provide it, they provide it. If you come up in here and you tell me that my staff didn't do it, didn't order the transcript, that they didn't respond to it, you want to ruffle my feathers, you insult my staff. So
I don't
don't. I'll consider anything you're saying about that afterwards, just an apology to Emily. I'm just going to set this for, well, I'm just going to set it for trial. The final settlement conference is going to work. Give me a trial date on a Tuesday
I can't.
of this month.
Could we possibly set it for August?
No.
I
Ma'am, I'm not going to delay this out. You paid no rent.
Okay, but I have a class on Tuesday.
Ma'am, I get, we all have different things on Tuesdays. We all have different things, different times. I'm going to set it for trial. You've not paid them any rent. You're claiming that they stole your stuff. You're claiming that they didn't help you. Well, I'm going to get to the bottom of it, if that's what it is. So I'm going to set non-jury trial in this matter.
Are we
For July 23rd.
So does that mean like jury and stuff?
No, ma'am. No jury was requested. July 23rd, 2024. That will be at 9 a.m. That will be in person. Ma'am, you make sure that you have all of your witnesses, all of your evidence. We'll hear it then, and then I'll make my decision.
Your Honor, can I just ask you, because I know I've on that day, I have another, I don't think it's at 9 a.m. Let me see. Oh, it is. Okay. All right. And I understand you want this one in person. So I'm not going to request, even though it's past the deadline. Okay. Thank you.
Thank you.
Judge Simpson does not give either side a quick win here. The landlord wants possession or rent accountability because the tenant has paid nothing on the new unit. The tenant says the situation is unfair because of alleged stolen property, maintenance concerns, and promises she believes were made during the move. But Judge Simpson's ruling is practical. This is going to a non-jury trial on July 23rd, 2024 at 9 a.m. in person. That means both sides must bring evidence, witnesses, and documentation, and the judge will decide after hearing the proof. The key takeaway is simple. Emotional claims may explain a dispute, but they do not replace evidence. Also, unpaid rent creates serious pressure in housing court, even when the tenant believes the landlord mishandled other issues. This case is a lesson in timelines, credibility, and documentation. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.